Barristers/solicitors, what split second in court made you internally scream, "Uh-oh, this is bad"? Story 1. The Helpful Defendant. Story from a friend of mine. He was defending a guy in court. Don't remember what he was charged with. The main witness for prosecution was on the stand and was asked if she could identify the defendant. She was scanning the courtroom and seemed confused. My friend was already silently celebrating because if she couldn't identify him, he could probably get all charged dropped. As he was mentally adding this case to the quote-unquote win file, he happened to glance over at his client, who had just helpfully raised his hand to make it easier for her to identify him. Even the judge facepalmed on that one. Story 2. The Unexpected Substance Trade Confession. Never ask a question to which you don't know the answer. Prosecutor suggested to me client that the canned goods he had burgled were to be used to trade for substances. Me, thinking the idea ludicrous, asked my client whether he has ever traded food for substances. To which he replied that he once exchanged a frozen chicken for a restricted substance. Needless to say, I didn't win that one. Story 3. The bail revoked over flight risk. Sat in the public gallery at a bail hearing for a man accused of heinous crimes against a very young relative. The judge started laying out the conditions of bail, and one of them was to surrender his passport. Man turned to his attorney and said, loudly, words to the effect of, "But you said I could fly back to my home country." The judge stopped himself and revoked the man's bail. Story 4. Demonstrating the injury. A lawyer I used to know was in court on a work injury case. The judge asked his client, "Just what is the nature of your injury?" His client replied, "I can't raise my arm this high anymore," while she raised her arm up to show just how high she couldn't raise it. Story 5. The Judge's Malpractice Hint. I was prosecuting a contempt action in family court, something that basically never works, and everyone in the room could tell I was winning. The other side was unprepared, out of arrogance, and I was basically ripping this guy to shreds on cross-examination, which his lawyer didn't even think would happen, because he expected the case to be dismissed. At the end of the trial, the judge ruled for me and stated that she found the defendant's testimony to be untrustworthy. I was shocked at winning a contempt trial to begin with, but then this exchange happened. Defendant's attorney: Your Honor, now that you have found my client's testimony to be untrustworthy, I am requesting a continuance in order to prepare further witnesses. This concept is shocking in and of itself, because to even think you can bring more witnesses after you rest your case is laughable. Judge: You had your shot and you missed, counsel. Defendant's attorney: Your Honor, there was no way I could have anticipated that you'd find my client's testimony untrustworthy, and as such, I didn't have the opportunity to prepare other witnesses in support of his position. Judge: That may be an argument for your carrier, counsel, but it holds no water with me. See you this afternoon for sentencing. For those who didn't pick up on it, the judge basically told the lawyer on the record in front of his client that she expects him to get sued for malpractice because he messed up so royally. That was mind-blowing on multiple levels. Story 6. The Pothole Photo Surprise. I was the defendant, representing a non-profit that I volunteered for. The plaintiff was a 60-something grandma who was looking for a retirement settlement after falling out of her jacked-up pickup truck in our parking lot. The premise of her case was that our parking lot was in bad shape, it was, and that she fell into a pothole and broke her leg, which resulted in her having to take Coumadin and diminished her enjoyment of salads at the Friday night fish fry. No, really. It was going along fine until my lawyer put up a photo of the pothole, taken the day of the incident, filled to the brim with water. She had claimed the pothole was dry and hidden, but the photo showed otherwise, and her reaction was pure panic. Story 7. Defending the Neighbor's Burglar. I have another one that I've just remembered. Representing a guy accused of housebreaking, managed to persuade the prosecutor that they couldn't prove it, So they dropped the case at the intermediate diet, procedural hearing, before the case called in court, headed downstairs to the cells to break the good news to my client, who was remanded in custody. Have an idle glance at the details of the charge while I'm waiting for the cell's staff to bring him out. The house that was broken into was my, then, next-door neighbor. Client was delighted that he was getting out. Him. Ah. Cheers, pal. You're the man. Can't wait to get out. Me. No bother. Right. See that place you definitely didn't break into? I live next door, so gonna leave my house and car alone, please? Him. Aye, sure, pal. Me and the boys go up there stealing all the time. What car do you drive? I told him what kind of car it was. Needless to say, my car was broken into about 3 weeks later. Story 8. Wearing the evidence to court. Literally the first thing I ever did was just a law student intern. Guy has a legit defense on a drug possession case. Drugs found in a jacket. Guy wasn't wearing jacket. They were going to have a very difficult time proving the jacket belonged to my guy. Had a long meeting with client. Explained everything. Client was excited. Day of the preliminary hearing. Guy shows up and sits down directly in front of the officer who arrested him, while wearing the jacket in question. The exact same jacket we were going to say they couldn't prove belonged to him. Story 9. The calendar mishap. Actually a lawyer. Oh crap. Moments shouldn't happen in court. Any surprises should be ironed out in discovery. If you're in court and have an oh crap moment, more than likely it's because you didn't do your job. My oh crap moment was going in for a status conference, and then finding out I had a second status conference on another case I was completely unprepared for, because my assistant didn't put it on my calendar by mistake. I told my opposing counsel my situation, and him being a generally nice guy who I got along with regularly, he told me what was going on in the case, and we went in and got an amicable result from the judge. Sorry, but that's how legal practice actually goes most of the time. Story 10. The forgotten reason for court. My ex forgot why she was in court. Not a lawyer, but fully 2 years after we dated, a crazy ex got a restraining order on me as revenge for saying her tattoos sucked. She said I'd assaulted her and made threats. We go to court. She tells her side. Judge picks at a couple holes in her story, then asks her, per the law on restraining orders, how she feels I am a threat to her safety, security, and privacy. Nobody should be able to say that about my tattoos. The idiot just finished saying I was a crazed predator, and then completely forgot. Story 11. Mentor matches robber description. Not exactly in court, but I was defending a juvenile robbery case, where there was very little evidence. There was supposed to be 2 guys, but they only picked up this one kid. He had no stolen property on him. He was picked up like outside his own house, wearing different clothes than the victim had initially said. This kid was on the honor roll at school. His family seemed kind and were involved. He wrote poetry and played instruments. I actually believed it was a legit, mistaken identity case. I went to meet with one of the kid's mentors for a character reference, and he exactly matched the description of the other robber. Story 12. Defendant vapes in court. Sitting in court, doing some plea paperwork with a defense attorney for a go-home plea agreement, where person is released from custody and doesn't have to do jail time, we hear this, KSSSSSSSSTTSHHOOOOO to our left, and we look to see his guy sitting in the galley all by himself, sitting in the cloud of a biggest vape hit I have ever seen, then has the audacity to tell the judge it went off in his hand. Do not pass go, do not go free that day. Story 13. Death of opposing counsel. Lawyer here. I had a pretrial conference at 9 a.m. at a court about 2 hours away. So I wake my ass up super early to drive in bad weather to the conference. I get there and we're waiting for the other in-town attorney. All the while I'm grumbling to myself about how I'm from out of town, and I can still make it on time. Finally, the court calls the other attorney's office and gets a receptionist who tells us through tears that other attorney passed away the night before. Needless to say, I was just happy to still be alive, and we rescheduled for a few months later. Story 14. Incriminating Prison Tattoo. I'm not an attorney, but a reporter whose beat is the county courthouse, so I've had plenty of these moments happen in front of me. A guy was convicted of attempting to harm several police officers. At his sentencing, the prosecutor revealed the defendant got a prison tattoo while he was awaiting sentencing of a tombstone with the names of all the cops he attempted to harm. But the defendant still had the audacity to beg for a lenient sentence. He got a few hundred years in jail. Story 15. Intern Mistakes Penalty Time. I was interning during law school, prosecuting domestic violence cases. The deputy district attorney asked me to talk for the first time during a guy's arraignment for beating his wife. An arraignment is when the defendant hears the charges against them and pleads guilty, or not guilty, basically. When the judge calls on me to speak, I got insanely nervous and told the defendant that his charge carried a maximum penalty of 30 years, when it was actually 30 days. He freaks out. The crowd, some in the gallery were his family and friends, gasps. The judge basically stops me and says, "I think you mean 30 days, counselor." After which everyone, including the defendant, laughed at me. Story 16. Witness Mistake Proves Innocence. I had a client charged with battery. The alleged victim didn't really support the prosecution's case, and in any event was reluctant to testify. They still had another witness, though, and she said that my client was hitting the alleged victim, so it wasn't looking great. The prosecutor and I were talking before court started, hanging out by the courtroom doors, when the witness walked in. She looked right at my client, who was sitting not 5 feet from me, then scanned the room and said, "Where is client name?" The prosecutor and I looked at each other for a minute, and then he said he needed to check on something. When I saw him a few minutes later, he told me he was dismissing the case. Story 17. Bias Exposed in Custody Battle. It was day 2 of a child custody modification trial. The opposition and her attorney were and are completely crazy. Their allegations were so weak that I told my guy, "Heck it, let's go for custody ourselves." I'm cross-examining mom about her proposed custody plan for dad in some detail, and I ask her, "Would you accept this for yourself?" She snaps back, "Absolutely not." I ask, "Why not?" "Because I'm a mother." To his credit, my guy kept a straight face the entire trial and never once got annoyed. Her petition was denied outright. Ours was accepted by the court. If the mom or her lawyer hadn't been such pains to deal with, my guy probably would have agreed to some small reductions in his custody just to keep the peace. Instead, the judge gave us nearly everything we asked for. Story 18. Ridiculous Nudity Claim. I had a ton of these when I used to do family law. Off the top of my head, my client's husband was alleging she had been high and nude in public. As I'm crossing him, I get him to admit that she was, in fact, changing out of her bathing suit at the beach and covered by a towel at all times. He says, "Well, she was naked. Under the towel." I come back with, "Just like you're naked under your clothes right now?" Even the judge chuckled. Story 19. Witness Testimony Clears Defendant. I was testifying for the defense. A young man had been arrested for assaulting a police officer, allegedly throwing bottles during some unrest in Oakland, following the verdict in the trial for the cop who shot Oscar Grant in the back on the BART platform. I had been there filming stuff, caught his arrest on video, and his brother found my footage on YouTube and asked me to testify. I had only seen bottles being thrown from this one corner of a parking lot, from behind me, with the bottles flying over my shoulder. The defendant was in a group in front of me. On the stand, the prosecutor seemed to think I knew the defendant, and was there basically committing perjury on his behalf. I explained why I had been there that night, that I had never seen this guy before, hadn't been coached by the defense, and hadn't been paid other than a small amount for my travel and time. Finally, exasperated, after much back and forth, the prosecutor says, "Well, if you don't know the defendant, then why are you here testifying for him?" I thought for a moment and said, I guess I just wouldn't want an innocent man to get convicted for a crime he didn't commit. He got visibly flustered and quickly moved on, trying to insinuate that if I didn't know him, how would I have known to be looking in his direction to see whether he was throwing things? And I tried explaining that if you're looking at a group of random people, and one of them throws something, you will naturally fixate your attention on that person. But because nobody in that group threw anything, there was nothing to notice in the first place. It looked like the police just grabbed him at random. They rested, the defense attorney bought me lunch down the street, and then he got a call from his colleague that the jury took all of 10 minutes to return a not guilty verdict on the assault charge. They said my story 20, coaching exposed in child interview. I was reviewing the transcript of an interview with a child. The child made incriminating statements against my client. At one point, when discussing the allegations, the child used an odd word, but I didn't think much of it. A few days later, I was watching a video of the child interacting with their grandmother, who hates my client, from about a week before that interview. The grandmother used the exact same odd word, in the exact context the child later used it. At that moment, it became clear that child had been coached. It was the first real aha moment of my career. Story 21. Client omits crucial information during deposition. Unfortunately, my best story for this is from my own client. We had a client who was on the board of directors for a company and was being sued for allegedly not telling the board something. His part of the case was really only a smaller part of a larger and more complicated case. So while there were a lot of other issues in the case overall, the entire case against him specifically essentially boiled down to whether or not he told the board about X. I and a few other attorneys spent an entire week, 9 a.m. to 5 p.m. or later, Monday through Friday, prepping this client for his deposition by going over every document in the case with him and explaining why it was important. On several occasions, we reiterated that no matter what else happened in the case, as long as we can show that he told the board about X, he was fine. The day of the deposition arrives. Opposing counsel sits down and starts questioning our client. In the first 5 to 10 minutes of the DAPE, opposing counsel straight up asks our client what he told the board. Client responds, "I told them about Y, I told them about Z, I told them about A, B, and C, and says nothing about X. Literally the only issue in the case against him. In 20-plus years of practice, it was the closest I've ever come to rage quitting on a client." Story 22. Mom admits to selling prescriptions in court. I was tangentially involved in a custody dispute. Dad alleged Mom was doing all sorts of things, and he should have the kid. Dad's attorney grilled Mom for about 20 minutes on texts she had sent claiming to sell her prescriptions. She wouldn't admit it. Dad's attorney moved on and eventually ended with, "One more question. Where did you get the pills you were selling?" Mom responds without thinking, "Oh, my doctor prescribed them." Story 23. Client caught staging slip and fall on camera. Years ago, I worked in personal injury, and we had a woman come to us saying that she slipped and fell outside of a nail salon because they hadn't swept up the wet leaves outside the door. So we take the case, and almost immediately we get a call from opposing counsel saying he's going to courier us something important. We open it, pop the disk in the computer, and right there is security cam footage of our client picking up the wet leaves, putting them on the sidewalk, and sitting down on them before calling for help. I have never facepalmed so hard. Needless to say, we dropped the case. Story 24. Bylaw officer misclassifies motorcycle as non-automobile. Had a bylaw officer harass me almost constantly for 8 months for violating a bylaw. I had parked my motorcycle in my driveway. He ordered me to remove it and tried to levy fines for the violation. He went after my landlord and tried to get me evicted. Eventually, I got a lawyer and filed a complaint. When asked to point to the bylaw I was breaking, he did, and even read it out, which basically read, "No parking or storing anything in a driveway other than an automobile." He seriously thought a motorcycle wasn't an automobile because an automobile is a car. When I hired my lawyer and showed him the case, he said, "I'm not taking new clients right now. but I'll make an exception because I'm personally offended that this is happening to you. Everything was thrown out, and I'm currently working on getting my legal fees and extra payments for all the harassment. Story 25. Doctor admits withholding critical medical information. A doctor testifying under oath that he deliberately chose not to inform a pregnant woman of a positive test result for a really severe genetic disorder because he figured because she was a member of his church, she wouldn't have considered ending the pregnancy under any circumstances. A primary care doctor who received a complex and technical test report from a genetics lab and simply forwarded it to the patient, who didn't really speak English and wasn't medically educated. She testified that she performed the minimum required diligence, which is not what you should say, and expect a good outcome. Story 26. Client admits to abuse in custody dispute. I was representing a client in a custody dispute over his children after a divorce, with his wife accusing him of physical abuse. He was asked if he had ever abused his wife, and he straight up said yes, but only when she annoyed me, or something along the lines of that. I was ready to straight up leave the courtroom and laugh my head off. Story 27. Co-counsel's client insults witness in open court. Co-counsel on a case where guy's being accused of intimacy with a minor. Idiot client goes off topic and testifies that the woman, quote, smelled like a lady of the night. Judge asks him what a lady of the night smells like. Client admits he doesn't really know, but assumes just like an American one. I'm like 2 weeks out of law school. This was all in open court, so I'm not violating any privileges here. Story 28. Menendez brothers caught lying about gun purchase in trial. Obligatory. I am not a lawyer, but this fits the bill pretty well. During the Menendez brothers trial, when Eric was testifying that he and his brother went to the Big Five to purchase handguns in August of 1989. According to Eric, when told that there would be a 15-day waiting period on them, they chose to purchase shotguns instead. Eric even mentioned the case and shelf where the handguns had been sitting. The attorney then paused and said, "Mr. Menendez, did you know that Big Five stopped carrying handguns in March of 1986? It basically undermined the credibility of the Menendez brothers' testimony since they were caught lying under oath about the guns, which also made people believe that the molestation accusations against their father were also lies. The initial trial was deadlocked. However, the second trial saw them both convicted of the acts. Story 29. Prosecutor's homophobic remarks backfire in substance case. A law professor once told me about a case from decades ago when he was defending a young woman on substance charges. In court, his line of defense was basically to tell the truth. This woman had turned to substances due to trauma and instability in her life, but she was now in a steady, loving relationship with another woman. For the first time, she had some peace and security in her life, was genuinely working on overcoming her demons, and was unlikely to reoffend again. It was a 50-50 proposition on how this would land with the judge, until the prosecutor stood up and started lambasting the two women, the accused and her lover, for lying because lesbian relationships aren't real, and similar stuff. According to the professor, everyone in the courtroom except the prosecutor could see that the judge was obviously gay, so this did not go down well. The judge tore strips off the prosecutor, gave a furious lecture on gay rights, and ended up giving the woman a slap on the wrist and wishing her well with her partner. Story 30. Client wears incriminating boots to assault trial. My client was charged with aggravated assault, 5 years possible, for kicking a guy badly while wearing cowboy boots with those fancy steel ornamental tips on the boots. He wore the boots to his jury trial. Story 31. Denied conviction, exposed in deposition. I was deposing a guy in a large breach of contract/fraud action. I asked him if he'd ever been convicted of a crime. He said no. Later in the dep, I asked him the question again, and there was no objection, and he answered no. I then whipped out his indictment for felony fraud and his conviction for misdemeanor conspiracy, and he denied it was him until I started asking about his co-conspirator, his son, and then he gave me the, "Oh yeah, I remember something about that." Story 32. Disabled claimant caught roofing his house. My brother is an attorney. He had a case where the guy said he was permanently disabled from a work accident. At a deposition, my brother overheard the guy talking about getting his house remodeled. He was already spending the money he thought he was getting. My brother drove by the house to see how much work was being done and saw the guy carrying bundles of roofing shingles up a ladder to the roof. This was before smartphones, so he drove to a store and bought a video camera, went back and recorded the guy. He had copies made and sent to the other attorney. The guy dropped the suit and was back at work the following Monday. My brother's client didn't want to pay for the video camera. He saved them thousands of dollars. They eventually paid, but he still gets a little peeved when he talks about it. Story 33. Jail calls and witness identification sync self-rep defendant. When I was a prosecutor, I had a guy who was representing himself. He was charged with car theft and evading. He was actually able to escape the cops for quite a distance and was captured later. His defense was that he wasn't the person. I got his calls from jail, and he talked so much to his girlfriend about how he had committed the crimes. The look on his face, when I told him that I was providing him copies of his jail calls, was great. I remember an even funnier thing. I had another guy who was representing himself. It was a residential burglary, and one of the elderly neighbors saw the defendant running from the house. At trial, the defendant was cross-examining the witness, and he asked, "Now, when you saw this person running away," and the witness said, I saw you running away." Story 34. Admitted choking in protective order hearing. In a protective order hearing, a respondent admitted on cross that he choked his partner. His attorney looked like his head was going to explode. The judge still only granted an order not to abuse. He wouldn't grant the stay away, or any other relief we asked for. Go figure. Story 35. Ice bucket challenge undermines injury claim. Plaintiff alleged he was so injured in an auto accident that he couldn't work, do any regular activities, or pick up his young kids. He then posted on his public Facebook profile him doing the ice bucket challenge. If you're not familiar, he basically lifted a huge cooler filled with ice water over his head. His attorney had no idea he had posted it. Story 36. Aerial photo backfires in boundary dispute. This is so petty. I've had much bigger moments, but because of the character of the other side, this will always be my favorite. Doing a boundary dispute, a squabble over what was essentially a few inches of land. Opposing side was a lawyer, and an absolute jerk. He was acting for himself. The whole, "a lawyer who acts for himself has a fool for a client" thing was bang on for him. But he was a deeply unpleasant guy, a bully who thought that he was the smartest guy in the room. Part of his case hinged on wheelie bins, and how prior to the boundary having been moved, there wasn't space to store a full-size bin beside the house. The fact you now could meant clearly the boundary must have moved. That was the extent of his evidence. It really was thin stuff. During the actual trial, he pulled a fast one by suddenly producing an old aerial photo, ostensibly to show the boundary at the front of the property had also moved. A fast one, because you have to disclose stuff like that in advance. You can't just sit on something relevant and then suddenly whip it out at trial with a flourish. Whilst he was making his submissions that it should be admissible, I looked more closely at it, away from the bit of the boundary he said it was relevant to, and realized that it very clearly showed a wheelie bin in exactly the spot his case said there couldn't be one. Told the judge we were happy for the photo be admitted after all, got the other side to confirm the date it was taken, then pointed out he'd just completely ruined his case. That photo did him for nearly... Story 37. Officer logbook contradicts testimony in drug case. A woman was charged with possession of a large amount of cocaine. Her boyfriend was a known, big-time substance dealer with a long list of priors. Her story was that 4 officers, A, B, C, D, came up to her outside her home and demanded to know where boyfriend was. They wanted all sorts of information about boyfriend and his associates. When she refused to tell them anything, she says Officer A threatened her, including pulling out his gun and pointing it at her. She also indicated that Officer A was wearing street clothes, while B, C, and D were in uniform. Officers claim she gave them permission to search her home, where they found the cocaine. She says she never gave them any such permission, and they planted/pretended to find the substances. Officer A, it turns out, had been in the newspaper shortly before the case went to trial for various serious incidents of abuse and corruption. The prosecution naturally assumes this woman is lying and simply trying to take advantage of the media publicity. At trial, B, C, and D testify that they were there with Officer E, not A. Once the defense theory developed a bit, the prosecutor brings into evidence a handwritten schedule logbook thing that listed which officers were working on each day, to show that Officer A wasn't even scheduled to work that day. There were various reasons this log might not have been admissible, and it was never disclosed to the defense until right before they attempted to admit it. But I quickly looked it over and, somewhat to the surprise of the judge, did not object to its admission, did not make any reference to the log until closing argument, then showed it to the jury and told them to look at it more closely. Officer A was not listed as working on the date, but the log also shows duty assignments for the officers working. Officer B is listed as being assigned to the evidence room or some such at the station, and Officer E is listed as being assigned to a patrol car across town with unrelated Officer F. Along with various other inconsistencies in the officers' stories, this led to a very speedy acquittal. Story 38. Harm trial reveals wrong victim shot. My grandpa has told me this story at least 100 times, but it's always entertaining. He was jury foreman for a trial in a small town in Tennessee. Two guys got in an argument at a bar with the victim. The two guys drove home, got a rifle, came back, and shot the guy. Months later, while on trial, the two guys are getting hammered by evidence and eyewitness testimony. These guys were idiots and left a huge trail of evidence. While the trial is about to wrap up, with them going down for a serious crime, the prosecutor brings in the final nail in the coffin, a surprise witness who happened to be the guy they had supposedly harmed. Those two idiots had harmed the wrong person, who happened to be in the wrong place at the wrong time, wearing the wrong clothes. Story 39. Self-rep defendant confesses in opening statement. I was prosecuting a traffic ticket and ended my opening statement with something similar to, "By the end of the day, you'll agree that the officer caught the defendant going 65 and a 50. Defendant, representing himself, stands up and says, 'While he may have clocked me going 65 and a 50. Judge stopped the trial, excused the jury, and was like, "You just confessed, Sue. Are we changing your plea to no contest or what?" Story 40. Rolex claim exposed as cover for affair. Not so much a gotcha as it is the defendant giving themselves up. When I worked for insurance defense, I handled a fraud case where a man reported his Rolex as being stolen. He was adamant that he was at a hotel and it was stolen. He has shown no proof of being in a hotel, so it's flagged. We go through the whole process and finally reach depositions. He gets sworn in and eventually let out that he wasn't at a hotel but rather with his mistress, and he had left it at her house. His wife noticed he didn't have it on, so he immediately claims it must have been stolen, etc., etc. This man decided to hire an attorney and go through this whole circus just so his wife wouldn't find out about his affair. Needless to say, the claim was denied. Story 41. Witness denies knowing offensive word until lawyer explains. I read a book once, and it was a story about lawyers and their cases. It was years ago, so I will try to recall one that sticks out. A lawyer was questioning a guy that assaulted someone at work. He was a dock worker, lawyer. So the person you assaulted said it started with you calling him a trollop. Guy: I did not call him a trollop. I do not even know that that word meant. Lawyer: You do not know what trollop meant? Don't you work on the docks? Guy: Did not know what it meant, so he is lying. Lawyer: Are you saying you do not know or have heard the word trollop before? Guy: That's right, but I know what it is now. My lawyer had to explain it to me. Lawyer: Are you saying you do not know what a trollop was until you met your lawyer? Story 42. Dog paw in photo reveals truth in flooring dispute. I acted for a plumber who ripped up a tile floor to replace a pipe. He installed new tile on top, but warned the owners not to walk on it for 48 hours. He emphasized not to let their kids or their dogs walk on it either. They walked on it but alleged the defects were caused by improper install. We had an expert do a report which confirmed that it was consistent with proper installation, but people walking on it too soon. Crazy homeowners still went to trial on it. In their evidence disclosure, they included a series of pictures. One of the pictures had in the foreground a tile that was tilted upwards. The background very clearly showed a dog's paw pressing down on the other end of the tile. That wasn't so much an I got them situation as they got themselves. Story 43. Costco purchases prove wrong oil used in car. I had client whose $60K car was ruined by a shop that put in the wrong oil. We couldn't prove it. At first the engine blew up, oil leaked out, and evidence was lost. I subpoenaed their bank records, figured out they bought their oil from Costco, called Costco, and got their prices for the last 2 years. I then worked out the amounts they were spending, did some backhand math, and showed based on the values it was impossible they had ever bought the right oil. They settled in full immediately. Story 44. Acting Coach DVDs reveal coach-child testimony. Told this story a few years back, but everything old is new again. My brother is a divorce attorney. His most memorable case, he was representing a guy in a divorce custody battle who was accused of horrific child abuse. Very graphic, very detailed depositions from the young kids against daddy. Things look grim. Then my brother notices the deposition transcript, done by social workers under oath, contains a question at the end from one of the kids. Did I hit my marks? My brother had previously tried to make it as an actor in Hollywood, right out of high school, failing miserably, and decided to go into law, an altogether different form of acting. He wonders how little kids know about acting jargon. Subpoenas the wife's personal checking ACCT during discovery, sure enough, acting lessons. Deposes an extremely sketchy acting coach, and panicked coach quickly coughs up DVDs of practice interrogations with the kids. Hours of coaching the kids on exactly what imaginary things to say about daddy. He says it was his one and only Perry Mason moment in 20-plus years of practice, and dad got sole custody of the kids. Story 45. Math proves chase was not high speed. Had a client accused of leading the cops on a high-speed chase. The cop on the stand estimated he was going 90 miles per hour, but never actually clocked him. Then the cop identified where the chase started with me and where it ended. It lasted about 2 miles. Then we went through his log of when it started and when it ended. About 3.5 minutes. Once you walk through the math on that, the average speed of this chase was 35 miles per hour. Client got acquitted really quickly after that. Story 46. Voicemail reveals landlord's intent to force tenant out. I was suing a landlord who failed to make serious repairs in order to force the tenant out. The hard part is proving bad intent instead of mere idiocy, so you get higher damages. Code enforcement was involved, so I request those records. The landlord left a voicemail to the enforcement department saying to hold off on the fines. They will make the repairs as soon as the tenant is forced out. That was an easy case. Story 47. Fish tank drainage causes massive flood. I represented an insurance company to recover monies it paid under a homeowner's policy, Google subrogation. It was a multi-million-dollar home with a 450-gallon custom fish tank on the second floor. The owner hired a company to clean the tank, and they brought in a fish specialist to make sure the fish were properly maintained/stored for the cleaning. The specialist then goes to lunch and turns it over to a 22-year-old they had hired a week before, who could have doubled for Keanu Reeves in Bill and Ted's Excellent Adventure. The kid just had to drain the tank and start cleaning. Up and until I deposed the kid, The fish tank company claimed they had properly drained the water into the municipal sewer system. Not the case. The kid, who has been fired long before I deposed him and didn't care at all about rolling on his employer, testifies that he used a substance right after his boss left, and then proceeded to drain the tank. But this was the first time he had done a second-story job. The hose they had wouldn't make it to where it needed to go, so he went into the nearest bathroom. Mindful of his customer, he didn't want to dump 450 gallons of dirty fish water into the tub or sink, so he leans the hose over the counter and into the toilet. Ends up walking out and leaving it there to grab some snacks. When he got back, there was 449 gallons of dirty fish water all throughout the house. The case settled within 3 days of the deposition. Story 48. Witness admits to missing accident while picking phone. My client was riding his motorcycle on a relatively calm street when this guy exited his garage without looking and run over him. In deposition, the guy brought a witness that was with him on the passenger seat. The whole time, the witness maintained that my client was driving too fast and that there was no time to brake the car. I asked him the same question a few times in different ways, making him tell the story again. In the fourth telling, he, already a bit frustrated, let it slip. "Look, I've already told you. We were exiting the garage and, soon as I lifted up from getting my cell phone on the car's carpet asterisk. Wait, so you didn't even see the crash?" There was no coming back from that. Story 49. Plaintiff admits no offense in discrimination suit. The plaintiff was being deposed in the lawsuit she filed, alleging sexual discrimination. She was claiming her boss had made some inappropriate innuendos and overtures. The defense attorney asked her if, when the alleged statements or events took place, was she shocked? No. Was she offended? No. Was she damaged in any way? No. So why exactly are we here? Well, honestly, I'd rather not be. Meanwhile, her attorney stared straight down, scribbling notes/doodling. We ended the deposition there and asked her attorney if this was going away now. We got a call later offering to settle for $1,000 and a letter of apology. My best guess is she was pressured by a friend or family to talk to an attorney, and the lawyers ran with it without really talking to their client. This video does not promote illegal activity. Stories are shared for commentary and education.